trouble in your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
All right, welcome to the show. Today is Saturday, which is miscellaneous cases, or cases that I don't normally have in a normal playlist. To the people who are subscribed to this channel, thank you very, very much for supporting my channel. I appreciate every single one of you, and welcome to my platform. So let's get this party started.
Yes, Your Honor. We're here today for sentencing in the matter of the state of Ohio versus Frankie T. Molnar, case number CR 25 CR 629. Mr. Molnar is present today in open court with his attorney, Mr. Bill Watson. At the last proceeding, which was held on June 10th of 2025, defendant pled guilty to one count, that being failure to comply with the order or signal of a police officer, an F3 under 2921.331B. Your Honor accepted the plea and ordered that the defendant undergo evaluations, specifically a PSR and a psych evaluation. We have read the report, Your Honor. We are ready to proceed with sentencing. There is no prior agreement between the parties as to sentencing. We would add that there are currently 86 days of jail time served, Your Honor. Thank you.
Mr. Watson. Thank you, Your Honor. May it please the court. I'll cut to the chase, Your Honor. Mr. Molnar's got quite a history, specifically a long traffic history. I knew it was not good, and I just learned prior to this hearing that it's even worse than I thought.
Can you please just hear me out? No, all work management platforms are the same. They take forever to learn.
Mr. Molnar on this particular day got scared. There, I believe at the time there was a warrant out of Chardon, and he obviously doesn't have a valid driver's license, and so he took off. However, he came to his senses. I believe he turned himself in.
No, he didn't come to his senses.
Well, Your Honor,
If he came to his senses, he would have stopped the goddamn car.
I agree with you there, Your Honor, and I think Mr. Molnar realizes that now, especially after sitting in jail for the past almost 3 months. I've had, an opportunity to talk to Mr. Molnar, and all I can say, Your Honor, is he has expressed to me that he is remorseful for what he did. He knows he's been struggling, not only with a place to live, but with work. And he knows that he has done better for himself in a more structured environment, specifically treatment facilities, inpatient treatment facilities, where he can focus on himself, his mental health, and ultimately his addiction to drugs. I know, based on his history, that there's probably little reason for the court to consider anything like that, but I'm hoping the court will take into account that he took responsibility immediately for this case. He is remorseful. You're going to hear from him in just a minute, Your Honor. He wrote a letter, and the fact that he wants to go back into a treatment program. Thank you, Your Honor.
All right, what do you want to say?
Your Honor, I'm sorry I made a bad decision by not stopping for the police officer that day, and if I could go back to that day, I would have stopped. At that time in my life, I was living in my car, struggling with drug addiction. About 2 to 3 weeks after I made that bad decision, I called to get some help with drugs and completed 2 treatment programs and was on my way to get into sober living, but decided it was best if I turned myself in on my warrants. I'm asking if I could please not go to prison and possibly go back to treatment and sober living so I could build more sober support in AA and NA and get back on my feet. Thank you, Your Honor.
Where were you going at 3:56 in the morning?
To Sheets gas station in Bishop Road, and
That's where you were when the cops saw you.
yeah.
Where were you going?
When I left there, I was going to Cleveland
For what?
to sell some of the stuff that I stole from the store
What store?
at the Sheets.
What'd you steal?
Some candy bars.
You're going to sell candy bars in Cleveland?
Yes, Your Honor.
Where's the hot market for candy bars in Cleveland at 4 in the morning?
Any stores that are open?
So you sell stolen shit to stores?
I was at that time for my drug addiction. Yes, Your Honor.
How much you get for a candy bar?
I mean, you get like $3, $4, to be honest with you.
What do they do with them?
Resell them.
How do they make a profit on stolen property like that at that price?
I don't know. Sorry, I'm just being honest with you.
When's the last time you got a license?
I thought I had one at the incident. It must have been suspended because of my warrant that I had for a probation violation. And
How many times has your license been suspended?
probably like 5 or 6. I think I've retaken the test.
Through 8/15 of 23, you have 63 traffic offenses. How is that even possible?
Your Honor, I do construction work usually, so I was doing a lot of driving. I had a bad habit of speeding. So I had a lot of 12-point where I had to do the remedial courses to keep my driver's license.
How fast were you going to get away from the cops here in Willoughby Hills?
I remember The fastest, he didn't chase me that far. I think he got my plate and then he backed off. I think I was up to like 60 miles an hour in a 35. I think. I don't know because I had my, to be honest with you, I had my lights off.
You turned your lights off?
Yeah.
So you took off from them on June 27th. This is too much shit to keep track of.
Your Honor, I was in treatment for like 7 months too. After like a couple weeks after, 2 or 3 weeks after that incident, I went to treatment. I was
Where?
Sky Point Recovery in Akron.
What do you got on that, Jennifer?
I did receive records back from Sky Point.
And what does that show?
Between September 17th and of last year and July 18th of this year, he completed PHP and IOP program.
And then on 7 days before you completed that, you committed a theft in Cleveland Heights. What was that?
That was the same scenario. You know, I have a warrant for them I need to take care of.
Well, I know you do, but why were you committing a theft after you just spent how many months in
Oh
treatment?
no, that was before.
Oh, I see. I can't keep track of you.
I'm sorry, sir. Your Honor.
All right, so it's 2 weeks after this Willoughby Hills that you're committing a theft. What were you stealing?
Well, the one was 2024, and I got out January 2025 out of Sky Point, and I actually went to New Day too for a month. I had nowhere to go, so I went to another treatment center after that. But it was June of 2024 is when this offense happened.
I know. And then July 11th was when the next one happened in Cleveland Heights.
July 11th, I wasn't even. That's impossible.
I don't know. Why do you have a warrant out then?
I didn't have a car or anything at that time on July 11th. That's probably when they issued the warrant. Maybe they.
Date of offense, July 11th of 24. Cleveland Heights Police theft.
Oh, it's 24? Yeah, because it's 25. Yeah. I went in July something in the Sky Point. Those dates are gotta be wrong. No, it's not right. I went in July. Oh, wait a second. No, July 21st, I was in Sky Point all the way to January. That's, swear to God, that's what the record says, Your Honor.
What happened in Cleveland Heights? What did you do in Cleveland
I
Heights?
took some laundry detergent. But that was before I went to treatment.
I understand.
Yes, Your Honor.
Actors, we can make you believe we know what we're doing, when in fact, we do not.
So what did you do between July 11th when you stole that time and then ran from the cops and September when you went into Sky Point?
I was living in my car using drugs. I went to work a little bit at Shake Pro Solutions off of Lee Road, 4500 Lee Road. That's where my job's been since 2014. But when my addiction got really bad, I couldn't even go to work anymore. So that's when I was doing anything to support my addiction.
So now you went to Sky Point, you're all cured.
No, I mean, I don't think I'm cured. I think I need daily maintenance, Your Honor. As far as going AA and NA, I do have some support group, trying to build a bigger one. I don't want to go back to living that life ever again.
Where'd you go after you left New Day on April 1st? Or after you left there?
I turned myself in. No, I went to, I turned myself in.
All right, you left Sky Point January 18th.
Yeah.
You entered New Day on April 1st.
Yeah.
What were you doing between January 18th and April 1st?
I stayed in a motel because I was working at McDonald's part-time when I was at Sky Point, and the money that I saved, they couldn't find sober living for me. So I was waiting for a bed and I never got one. So for 4 weeks, I stayed in a motel, spending $400 a week, burned through all my money. And then I was going to turn myself in, but I was scared to because I didn't want to go back to jail. So I went to Ashtabula and I ended up relapsing for about 3 weeks. And then that's when I went to New Day. And I went to New Day and they put me in a PHP program, and I figured I left out of that program too. I finished the New Day, the 30-day residential, but then when I went to their PHP, I figured I didn't need it again. I needed to turn myself in on my warrants.
Why did you figure you didn't need it again? And
I mean,
weren't you just coming off a relapse?
Yes, Your Honor, but I did the 30 days at New Day, and I just was sober for 6 months. So that's my thinking.
Well, you weren't sober for 6 months.
At Sky Point, I was there for 6
Okay.
months.
All right, and you got out and you started doing drugs again.
After, yeah, because I had nowhere to go. I had no place to live. Either turn myself into jail or go back into a bad situation, Your Honor. And I chose the wrong thing, going into a bad situation, but then I put myself back into treatment. And my thought was to go to get into sober living to try to get a lawyer and take care of my charges that I had. But then I decided I think it was more important just to turn myself in once I finished the 30-day residential, Your Honor.
I mean, what do you expect here? What do you expect from me?
I mean, I was hoping to get another chance and get probation and go to treatment, or just get probation.
You never,
and treatment on my own.
you never show up anywhere you're supposed to be. How can you be on probation if you never show up anywhere you're supposed to be?
I mean, I was on probation in Cleveland. I showed up every
Shit,
time.
that's like, I mean, an untrained monkey can finish probation in Cleveland.
Yes, Your Honor.
You couldn't do it in Chardon. Why not?
I wasn't on long because I was in treatment and they weren't sending the paperwork. They fired my caseworker, Your Honor, because he wasn't sending paperwork saying where I was at.
Who was on probation in Chardon?
I'm on probation in Chardon.
You were the caseworker.
Yes, Your Honor, but we weren't allowed to have phones or anything at that time. He was supposed to be taking care of my case for me.
Whose case is it?
Mine, Your Honor.
Okay. How old are you?
Unfortunately, I'm 51, Your Honor.
So, where are these stores you like to sell stolen stuff to in Cleveland?
In East Cleveland,
What stores?
there's a couple convenience on Euclid Avenue.
What's their name?
The one was the Pantry, and the other one, I'm not sure the name. It's just a convenient. It's a small, like, family-owned store.
Why didn't you show up in Burrito Court?
Because I was in treatment, Your Honor.
Now we got to go help people customize and save hundreds with Liberty Mutual. Maybe where's the golf cart?
Tell them you couldn't come to court because you were in treatment?
No, again, Your Honor, I know it was my responsibility, but I was dependent on what they were telling me at the treatment program. So no, Your Honor. Your Honor, I did write letters to everybody where I was at, though. I got copies of them. I think was sent to you. I don't know if they were faxed to her.
Who?
With the treatment, the lady back here.
Who's she?
I'm to my dad. Did you send those papers?
Well, who's the lady in the back?
She's the one that had the treatment records.
I don't know. What's her name?
I don't know. Honestly, I'm sorry.
Well, you got through probation pretty easy in Summit County, right?
Yes, Your Honor. That's one place at Sky Point because it was in Akron. That was easy to deal with.
I mean, they tied you up on probation for like 6 months
Yes, Your Honor.
without conditions.
Well, when I was in treatment, I just had to call and do video Zoom, Your Honor. So I seen him once a month on video Zoom and on my phone. They didn't make me report, and they sent over all the clean urines and stuff that I had to him.
Mr. Tavanchi?
Yes, Your Honor. The defendant has a string of felonies since 2008, a host of misdemeanors since the early 1990s, involving dishonesty, also involving violence toward others, and of course the huge list of traffic violations. More concerning perhaps is his handful of PVs, one of which led him to prison. He's received lots of chances, Your Honor. In fact, he's currently got, I think, at least 3 warrants out, and he was actually out on a warrant when he committed this offense. Another thing to consider that I asked the court to consider is that he has a prior conviction for the same behavior for which he's being sentenced today. This was a flee and elude in a motor vehicle, 1992. Yes, it was a while ago, but it's still there, and it's again for the same behavior there that he pled to already. We would ask that the court consider that history as well as the long 12 pages or so of traffic history when considering the driver's license suspension, Your Honor, if the court decides to go the probation route. With regard to this case, Your Honor, defendant ran a stop sign to begin with. Cops were behind him, he runs a stop sign, and he drives down Chardon at 73 miles per hour. About twice, at least twice the speed limit, Your Honor, not 60, 73. He speeds at least twice through flashing yellow lights. So he's going through intersections, splitting traffic, a couple of times, again, yellow lights, and in doing so, he's splitting traffic, he's driving through the center lane, which are for turning. And of course, as he goes through the intersection, driving into the oncoming turning lane. It's just, by the grace of whomever, that nobody was there. And it wasn't worse than it is. And he has his lights off at this time. So after all this, the defendant actually does downplay the chase. He said it wasn't a bad chase, but it was, and it was serious enough.
What does that mean, it wasn't a bad chase? What do you mean?
Your Honor, I didn't mean it was a bad chase. I meant that it didn't go for far. I drove up the street maybe a mile and he shut his lights off. I was getting ready to pull over.
I'm using your words, wasn't a bad chase. So that's how you define wasn't a bad chase?
No, Your Honor, I'm sorry. I didn't mean it to sound that way. Any chase is bad. Somebody could have pulled out the driveway. Anything bad could have happened. Thank God it didn't. And again, I apologize. I would never do it again.
You wouldn't need to thank God if nothing happened. If you weren't running around going twice the speed limit at 4 a.m. with your lights off. You wouldn't need to thank God.
Yes, Your Honor.
You would start acting like a responsible person, and you wouldn't need to thank God for it. Go ahead, Mr. Devanshi.
Thank you, Your Honor. The chase didn't last for a long time, but he did a lot in those short moments, Your Honor, as I've already indicated. It was serious enough so that officers who were engaging him tried to deploy spike strips to stop his vehicle, but they weren't able to do that because he was going just way too fast. In fact, he just drove right by the officer that was attempting to do that. Eventually, of course, the officers have to end the pursuit for safety reasons. For all these reasons, Your Honor, yes, there's no doubt, I think, that the defendant has a drug problem, a mental health problem, and that maybe he needs help, but he's been giving a lot of chances. He seems to have completed only one program, although he seems to have been enrolled in several.
You could borrow anywhere from $26,000 to $250,000 to fund your dream renovation.
As I've said, Your Honor, he's been to prison. He committed this while out on a warrant. Our recommendation, Your Honor, would be prison, although we would understand the court's decision if the court were to actually rule that NeoCap would be the better route. Thank you.
All right, I've reviewed the pre-sentence report and the psychological evaluation. I've considered the provisions of 29, 29, 11, 12, and 13. Listen to counsel, listen to the defendant. You don't have 63 traffic violations because you work construction and you drive a lot. You have 63 traffic violations because you don't give a shit about anybody but yourself. You have a failure to comply because you don't give a shit about anybody but yourself. That's why you have those things. So you've come to be 51 years old and you don't give a shit about anybody but yourself. I put you on community control for 5 years, 180 days in jail, credit 86. The last 30, you're going to be in the jail treatment program. Even though you've completed a program, you're going to do another one. Follow the recommendations. Then you're going to go to NeoCap. Complete it, follow the recommendations. Then you're going to go to a sober living facility for a minimum of 6 months and complete that program. You're going to have no drugs or alcohol and you'll be screened. You're going to have only one doctor, one dentist, and one pharmacy for prescription medication. You're going to take your medication as prescribed. You're going to sign releases for probation. You're going to get a mental health evaluation, follow all recommendations. You're going to attend at least 4 AA or NA meetings a week and get a sponsor. You're going to obtain and maintain full employment, complete the decision points program, and pay the cost and supervision fees. Any other terms, Ms. Knaus?
Thank you.
You understand all the terms?
Yes, if you understand all the terms.
Yes, Your Honor. Is that 6 months in jail and then the last 30 is jail treatment? You already get time served for,
You get credit for time served,
so I got 3 more months in here?
approximately.
Well, we could do something else. You want to do something else?
No, Your Honor.
You sure?
Yes,
Because
sir.
you seem a little pissed off that you got more time. So
Because
we
I'm
can do
going
something
crazy.
else.
I'm not getting no mental help,
Okay.
Your Honor, in the
Okay.
jail. I'm
Okay,
going crazy
so we
being in
should,
this
so we
jail.
should do something else.
No, Your Honor, I'm sorry.
Okay, then what are you bitching about?
I'm just upset. I'm sorry.
You're upset. I'm upset. I'm upset that you got 63 goddamn traffic violations and you're running from the cops at 4 a.m. because you're stealing fucking candy bars. I'm upset. You're upset? You're upset at me or are you upset at you?
At me, Your Honor.
Okay.
For sure at me.
So, let me continue on. Do you understand all the terms?
Yes, Your Honor.
Okay. If you don't comply with the terms, and you seem very unlikely to comply with the terms at this point, then the state will file a motion to terminate your community control. And if I find you violated, I'll terminate it, and then we'll just send you to prison for 36 months. Do you understand that?
Yes, Your Honor.
I mean, I'm sorry to interrupt your daily routine like this.
No, that's not you, Your Honor. It's me.
10-year license suspension.
10 years?
10 years to the date of the offense. 10 years. Now you pissed off about that? He's pissed off about that now. Guy's got 63 traffic violations.
Your
And
Honor,
you're
I've been
pissed
punished
off
for those.
that you're running from the cops at 4 a.m, going twice the speed limit, and you don't think anything should happen.
Yes, Your Honor, I do. I've just been punished for all them 63 ones, though.
I don't know.
I paid a lot of money.
The longer I'm here, the less I understand about people.
Yes, Your Honor.
I mean, what I should do is I should make it a lifetime. That's what I should do,
Please don't, Your Honor.
but I didn't.
I thought it was 3 years.
You're trying to talk me into a lifetime. Anything else?
Question, Your Honor, anything with regard to PRC?
Well, not until I sentence him to prison after he fails.
Okay, thank you.
Anything else, Mr. Watson?
Nothing further.
Funny.
What?
That's funny.
That's funny. You want? Hey, we're not done yet. You want? Is there something else you want to try for?
No, sir. No, Your Honor.
Well, what was so funny?
I mean, I don't know, this guy never did nothing to him. He made it sound like it was like I tried killing somebody, like I committed murder.
Well, you know, that's kind of like the guy that was driving down Route 2 in June of 2018 and hit a cop and killed him.
How am I supposed to have a job without a driver's license for 10 years?
Whose problem is that?
I know.
Why don't you find?
That's why I'll fail.
Why don't you? You fail if you want to fail.
I don't want to fail. No.
Well, then don't.
After I had my kids, I hit a wall I'd never encountered before.
Thank you. This is case number 214C0633. Final settlement. Okay, look, somebody's got their mic on. I'm going to cut you off if you don't turn it on mute.
Hello? Waiting.
Somebody identify themselves. They've called in on the phone, 734.
I'm actually doing stuff right now.
I want everybody to put their microphones on mute. If you don't do that, I'm going to cut you off. With the person who's calling in from 734, want to identify yourself, please? Now they put it on mute.
Whitney Passano.
Say it again.
Whitney Passano.
You want to, all right, good. All right. Case number 214C0633, Hero Handyman LLC versus Whitney Passano. Mr. Passano, I know you're on the phone. Is there a representative from the plaintiff, Hero Handyman LLC?
Yes, Your Honor. Good morning, Your Honor. This is Alexander from Handyman Hero. How are you?
I'm fine. Can I have your last name, please?
Kronung.
All right, Mr. Kronung. All right, we're here today on a final settlement conference. As I understand the pleadings, there was a contract for $549 to do some handyman work. You did the work and you still have an outstanding balance of $188.79. As I go down here, I've got some claim for $2,058, which I don't understand. But, okay, let's do this. Let's get both of you to raise your right hands. You both solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, Your Honor, I do.
Okay, Mr. Passano?
I do.
Okay,
I do.
good. Excellent. Mr. Cronin, why don't you go ahead and tell me the basis for your claim? I think I understand it, but I'm a little mystified by the claim being $188 and then cost being over $2,000. So.
Yes, sir, you are correct. The initial cost was $549. We did come out. Mr. Passino agreed to the work in writing. He confirmed in writing afterwards that the work looks good. He said that he will gladly pay us. He did pay us $360.21, confirming that he had agreed to at least doing the work, because at some point he had mentioned that he did not.
Okay, so I understand that, and I'll get with Mr. Pacino about whether or not he agrees that he'll gladly pay for the work.
I'll keep it simple. And
I want to
keep it
know about the 20,078.
Gotcha.
That's
Gotcha. So,
I mean,
so we filed an additional claim for tortious interference, and we had actually updated that in our amended claim on 2/28 to 2,887. That's for having to take 27.4 hours off of work to deal with this case, including attempting to serve Mr. Pacino himself, hiring, calling police officers because he was harassing us, hiring skip tracing, hiring process servers, driving to the court several times, and then also being in these Zoom conferences. One of them took the majority of the day, unfortunately. So when we add all the hours up, we get 27.4 hours that we were not able to work because we had to pursue this claim. We charge $105 an hour in our business, sir. We're a 5-star business, and the amount adds up to 2,887. That is, in fact, lost revenue and money that we did not collect because we could not be at the work site. So that is where that number is coming
Let me
from.
hear from Mr. Pacino. Mr. Pacino, what's going on here? You owe $188, and you're gladly willing to pay that.
Well, no, this guy originally was, well, it was my neighbor, and we were kind of like friends as well originally. But yeah, no, I called him to put if he could do put a pipe over here at the shop. He had to work. He said he wants the money before he leaves the job site. I said, well, this might not be a good day because I'm not going to be there to pay you. I can't pay you today.
Do you have a written contract here?
No, it was all just, I mean, the guy was like my neighbor and a friend for a couple years. And so, I just called him on the phone. I said, if you could do this pipe.
The first rule of corporate business is never do business with family or friends, but go ahead.
I could have told you.
Yeah, I mean, and he said he'll do the pipe. He couldn't tell me exactly what it was going to cost. He shot me that price of, somewhere that, something around $500, give or take. And so then, like he said, that he wanted the money before he left. I said, I can't pay you. I'm not going to be here. So maybe today's not a good day. But when I left, and then he made his way in the building through my coworkers, and he did do the work. And the work is okay. I'm not saying he did the work, and the work is okay. All it was to put a pipe. And then he says, well, I need $550. I said, well, I never exactly agreed to any price, but of course you did the work. I gave him $350, and he went bananas about this $150 that he believes that he decided that he was owed. I never agreed to anything verbally or in writing. I told him I had a conversation.
He's going to do it for free?
Monday.com, the opposite of any work platform we tried in the past. We tried other work management platforms.
No, I wouldn't. Of course I never thought for a second he was just going to come over here and give it to me for nothing. So, that's why I promptly paid him the $350, which was, it was all just, there was no paper, and then there was no verbal, you owe me $550. And he never said you owe me $550 before we started. He just came up with the price at the end. And, for him to go spend 27 hours over $150 seems a little over the top.
Okay. But, look, did you agree to the initial fee of $500 and some?
No, I never was given
yes
a price
no?
of $550.
That's a simple yes or no question.
No, I never agreed to $550 because I was never told $550.
Well, what did you think you were going to pay for this?
I figured it would be, anywhere from $300 to $500. I was estimating in my own mind. It's just 10 feet of pipe.
Look, this is the final settlement conference. I can't render a decision. What I can tell you is what I think is going to happen in front of Judge Cabby. I think he's going to grant the $188.79 of unpaid work. I think he's going to grant $75 in terms of court costs, and I think he'll apply something in the neighborhood of $100 for service. Mr. Cronin, the $2,000 plus is outrageously expensive. You can serve by mail. I mean, I don't know what the heck you were doing for 2007 whatever dollars. So I would think that a good resolution of this matter would be, let's see, 288 and 75, about 350 bucks.
Your Honor, may
Now, wait, just wait. I can't force you guys to do this. You're going to have to go to trial. You're going to have to pay attorneys. You're going to have to go through the whole process. All I can do is encourage you to settle this for $350. Now, if you want to do that, that's great. If you don't, that's fine too, because I don't have to try it. Judge Tabby does. So if that makes sense to both of you, great. If it does not, let me know and I'll set it on the judge's docket for trial.
Your Honor, am I able to represent myself in court at trial?
Sure, but you know the old adage.
I certainly do. I do think it's reasonable. By the way, I agree with you. Doing business with friends and family is dangerous without a contract, and I have ever since been using contracts with all of my clients. He did agree to our hourly rate of $105, and we worked for 3.5 hours.
Okay, I'm not going to argue this case. What I want to know is between the two of you. Look, you're going to trial if you don't resolve this today.
I'm absolutely fine for that. I believe in being compensated for my time. I don't work for free, and that includes the 27 hours that I've taken to pursue this case.
All right, fine. Then you try and convince Judge Tabby that you're entitled to that.
Okay, great.
Mr. Pacino, it looks like we don't have an agreement in the range that I have suggested. So good luck to you at trial. Same to you, Mr. Cronin.
Thank you so much, Your Honor.
Enjoy your time with Judge Tabby.
I like him. I sure will. Thank you.
I was going to tell you, I was just going to pay the $350 today, just based on your judgment, Your Honor. So
yeah, well, I appreciate that. I think that's a reasonable approach. But Mr. Cronin wants to go to trial. He's going to be Perry Mason. How he's going to represent himself in this matter and take testimony from himself and all of that is sort of a mystery to me. But he should have a good time with Judge Tabby doing that. Okay. I will let the judge know that we were unable to resolve this in the final settlement conference, and you guys will be getting a trial notice. Enjoy yourselves.
Great. Thank you.
Yeah. Bye.
Bye.
All right, our next case is case number 221C0191, Mark Feaster versus Mark Shepard at Gene Butman Ford. Mr. Shepard, I can see you're here. Good morning. Yes. Let's find out if Mr. Feaster has appeared this time. Mr. Feaster, case number 221C0191, motion to set aside by the plaintiff. Well, it's pretty simple. Plaintiff didn't show again. That may be 2 or 3 strikes, I don't know, but the motion to set aside is denied and the original dismissal is in place. Mr.
Thank
Shepard?
you, Your Honor. Thank you. Yeah.
You're welcome. Sorry to take your time. This is, 2 times the plaintiff hasn't shown. Okay, so I'm going to note that the motion to set aside is denied, and you are all set. You should get a copy of that, of my order.
Well, one question. Can he waste our time again on this? Your time and mine?
What, you want to do it again?
No.
No, I think we'll make this about as final as you can get. Okay?
Great. Thank you, sir.
All right. You take care. Thanks for coming.
All right.
Bye-bye.
Bye.
Hi, what's your name, please?
Akeisha Collins.
Miss Collins, I am super, super angry that this didn't get resolved yesterday. And I am so sorry because I know we had a whole conversation about what else was going on. And you heard all of us looking and trying to find out. And everybody was in agreement that nothing was coming and that you could go home, and we couldn't find it anywhere, including the prosecutor who was on here yesterday looking in his files, and he couldn't see anything either. So I am terribly, terribly sorry that you ended up having to spend another day in custody, and I am not happy that that happened. That is frankly frustrating and embarrassing for the court system, that we can't even tell a person what's going on in their life. That's not cool. I don't know that I can fix it, but I want you to, and it doesn't help you at all for me to tell you that I wish it hadn't happened, but I want you to know that it's not cool, and I recognize that. Mr. Burdell, can I help you?
Judge, I'm here on arraignment duty. I think I'm probably tagging in for
Ms. Reiser.
Ms.
Okay,
Reiser if she's
great.
finished, unless she'd like to, but I'm here.
Okay, awesome.
Thank you, Mr. Burdell.
Of course. Sorry to be late.
No, it's understandable.
Okay, what's your name, sir?
I'm a female.
I'm
And
sorry.
my name is
I am
Denise.
so sorry. I can't see you well enough. There you are. Of course you are. I apologize. I also don't have any females in my list. So,
Okay,
so hang
I
on one
believe it.
second. Tell me your name again.
Is Denitris Cargill?
Oh, I do have you in my list. I'm so sorry.
That's okay.
Okay, let's start over.
Oops.
Hello. Could you state
Hi,
your
how
name
are
for the
you?
record, please? I'm so sorry. All right.
That's okay. How are you?
I have you, the masks and the Zoom, it's all just a
That's
nightmare.
okay.
Well, it's not okay.
Hair don't make it any better, so.
Yeah, I couldn't see, it looked like if the way you had your
Right,
face
yeah,
tipped forward, I
exactly.
couldn't see your hair at all.
Yeah.
There you go. All right.
I don't doubt that sinking in. I can see it sinking in for him right now. He definitely doesn't want to find himself in that situation, I believe.
All right, court next calls the people of the state of Michigan versus Mackenzie Troy Carpenter, case number 252898, SM. We are here for a final pretrial conference. Ms. Lawrence appears on behalf of the people. Mr. Carpenter appears on behalf of himself. Mr. Carpenter, I just want to make sure that you're aware that you do have the right to have an attorney at all phases throughout this process. And if you decided that you wanted one and could not afford one, the court would appoint one to represent you. Do you understand that? Today, are you still requesting to represent yourself, or do you want the appointment of an attorney? All right. We are here for a final pretrial conference to a one-count complaint of disorderly drunk in, looks like, the city of Manton. Is there any resolution in this case?
Thank you, Your Honor. The offer right now is as charged. Mr. Carpenter did make some statements possibly wanting to hire an attorney, so I felt it was better to address this on the record, but there is no offer.
All right. Mr. Carpenter, I guess I had asked if you wanted an attorney appointed, but Ms. Lawrence makes the statement that you might wish to hire an attorney. Is that something you want to do?
I consulted with a private attorney, and he advised not to hire him.
All right. So it's still your desire to move forward representing yourself?
Can I enter a plea?
You're representing yourself, so.
I'd like to enter a plea of no contest.
Well, there's only certain ways that the court can do that. So what is the reason for no contest plea?
Can you elaborate?
The court can only accept a no contest plea under certain situations. And some of those situations might be civil liability or something like that. So what is your reason for requesting a no contest plea? No. We're not going to have that. Bailiff, can you put her one row back, please?
I don't want to overspeak Your Honor, but if you wanted me to, I could speak with him briefly to express what the public defenders might be able to do for him. I trust the court's discretion. I apologize.
Are you okay with that, Mr. Carpenter?
Wouldn't be in favor of that.
All right, Mr. Hartel, I'll give you the moment to do that.
Sir, can we talk for a minute? I appreciate it.
Yes. We are back on the record in the people of the state of Michigan versus Mackenzie Troy Carpenter, case number 252898 SM. Mr. Carpenter, I know you had the opportunity to meet with Mr. Hartel, and I think I heard him say he was filing an appearance. Are you now requesting the appointment of an attorney?
Yes.
All right. All right, so then we will, and Mr. Hartel, you're prepared to do an immediate appearance on that?
I am, Your Honor.
Have you had, well, looks like you had the opportunity to speak with the prosecutor's office. And since I've been given an exhibit, looks like we probably have an agreement. Is that correct?
Yes, Your Honor. I believe the defendant will plead no contest as charged.
No contest is charged, and the reason for the no contest plea?
Intoxication levels high.
That is accurate.
Mr. Carpenter, have you heard what the attorneys have said the resolution in this case is? That you'll be pleading guilty as charged, but no, I'm sorry, you'll be pleading no contest to the charged offense of a disorderly person drunk. And the reason for the no contest plea is lack of memory due to intoxication.
Yes, sir.
All right. And you understand that that is a misdemeanor punishable by up to 90 days in jail and or a fine of $500. In order to accept a no contest plea, the court is given something to review. In this case, it looks like it's going to be a police report. I would review that police report to see whether there's a factual basis to accept a plea or a finding of guilt. No contest means that you accept the responsibility without saying that you're guilty. Do you understand that?
Yes, sir.
And I would be able to use that police report for sentencing purposes. Do you understand that as well?
Yes, sir.
Ms. Lawrence, I've been provided with a Michigan State Police incident report number 071-000-2129-25. Do the people move for its admission?
Yes, Your Honor.
Mr. Hartel?
Yes, do we, Your Honor.
All right, People's Exhibit number 1 is admitted. Give me a moment to review that. Counsel, I have read the report. One issue that the court has is there's no level of intoxication in it. So there's nothing in the report to indicate that there would be a high enough level for lack of memory for no contest.
Your Honor, my client would be willing to make a limited statement that he does not recall those events because he knew he was intoxicated. I don't know if that helps at all.
Let's give it a whirl. Mr. Carpenter, will you please raise your right hand? Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Mr. Hartel? Do you need a report?
If I could add that back. I appreciate it.
Struggling with job hunting in 2025? Fellow is here to help. Upload your resume and our...
On June 28th at approximately 2 o'clock in the morning, do you remember anything at all from that period of time?
Waking up.
Before that, had you done anything that would have impacted your ability to have recollection?
I had drank personally and at a public house.
How much do you think you would have consumed over what period of time?
3 doubles in less than 2 hours.
Doubles of what, sir?
5.
That's quite a bit, Your Honor. I'm not a medical expert, but that feels like it would be enough.
Mr. Carpenter, what is the last thing you remember before waking up in handcuffs?
Being offered a ride from a friend and saying, no, I can walk.
Ms. Lawrence, are you satisfied with that testimony?
Yes, Your Honor.
As is the court, I find that the defendant in those situations is experiencing a lack of memory. May I have Exhibit 1 back, please?
My apologies, sir.
Do you counsel believe that Exhibit 1 provides a factual basis in which to accept the plea and that the court rules have been complied with?
Yes, Your Honor.
As you are, Your Honor.
as does the court. In particular, the report indicates that on or about Saturday, June 28th. Sorry, we didn't take a plea in this, did we? I think we skipped that step. Mr. Carpenter, to the allegation that on or about June 28th, 2025, in the city of Manton of Wexford County, how do you plead to disorderly person drunk?
No contest, Your Honor.
All right. Now to where I was, the state police report that they were called on June 28th, 2025 at approximately 02:18 in the city of Manton to a person who was an unresponsive male laying in the front yard and driveway. When law enforcement arrived, they encountered Mr. Carpenter, who was lying face first on his stomach, but breathing. However, he was unresponsive, had to be subjected to sternum rubs, and when he did become responsive, he tried crawling away from the roadway. Law enforcement could smell the odor of intoxicants coming from his person. He was placed in handcuffs and detained for safety. He attempted to stand up and walk. He was swaying back and forth. And as he stood, he could not walk due to his high level of intoxications, as they quote out of the report. Additionally, his speech was very slurred. He became agitated before screaming at law enforcement. And then it goes on to describe somebody that could have easily been charged with the resist and obstruct law enforcement. The court finds that the report makes these, provides a factual basis to accept the plea. Mr. Carpenter, I find that you are guilty of disorderly drunk. I also find that the interests of justice are well served in allowing the defendant to enter a no contest plea due to his perceived level of intoxication and lack of memory. Are we able to sentence today?
Yes, Your Honor.
Elocution, Mr. Hersell?
Yes, thank you, Your Honor. I do appreciate the court allowing this to be no contest plea. As my client did note, he has very limited recollection of those events. And I did meet with him, albeit briefly, earlier, and I do appreciate the court for letting me do so. He did make it clear that wishes he wouldn't have found himself in that situation, because even though he doesn't recall all of it, recalls waking up in the squad car. He recalls everything that's happened after that. And the embarrassment he believes that most likely causes for his family as well. If I understand correctly, that his mother is here, because I'm sure the court did note. He did advise me that he does plan to go on, if allowed, a family vacation to North Carolina on October 3rd for 4 days. I did want to get that out there just so the court's aware. To my knowledge, he hasn't had any issues on the bond. He's been using the sober link multiple times per day. I would always in these cases ask the court to consider fines and costs only. Because I was barely involved, I of course waived my attorney fee. If the court did believe this is a situation where either jail or probation would be required, I would ask the court to factor in that doing good on bond, in my opinion at least, means he is supervisable. So even though I'd ask the court to limit it just to cost, if there was a choice between the two, I'd ask the court to go with the supervision. If so, I would ask the court to fashion an ability for him to be able to go on that pre-planned family vacation. I do believe his mother would be with him for that portion of it. We do, of course, trust the court's discretion. I would throw in that based on my discussions with him, I do believe he doesn't have any recent criminal activity. So I do believe there was at least a significant chunk of time where he did not have issues with law enforcement. I am told that there was things in his past, but he has no desire to go back down this path. And unfortunately, things like sobriety, we do have slips sometimes, but he definitely has no desire to, as the court did note, this almost rose to a felony situation.
I don't think it almost rose. I think it was there. It just wasn't charged as one.
Noted, Your Honor. And I don't doubt that sinking in. I can see it sinking in for him right now. And he definitely doesn't want to find himself in that situation. I believe, in fact, he's done good with the sober link, proves how sobering this has been. And even these words right now between you and I can tell are sinking in, just the court is aware. Thank you.
Thank you. Ms. Lawrence, on behalf of the people.
Thank you, Your Honor. I know I don't need to go into too much of the facts since you just read the report, but I will say I did have an opportunity to review the body cam footage in this case, and the report is being generous. If I'm honest, Mr. Carpenter was extremely loud and rude and disrespectful and not compliant with these two troopers. Based off of my conversations with him, I don't believe he truly thinks he did anything wrong. Given that, I would ask for 5 days jail. I think also with his 2 prior convictions involving alcohol in the last couple of years may tell us that there might be a deeper problem here, so that people would ask for 5 days jail. Thank you.
Thank you. Mr. Carpenter, you have the right to address the court before sentencing. Is there anything you'd like me to know?
If you were ever inappropriately touched by a rideshare driver, don't ignore this. You could be entitled up to 500.
I would just like to apologize.
So it looks like you've been on the SoberLink device since, well, I ordered random testing. So did you opt for the SoberLink? And you've been on that the entire time you've been on bond? How are you finding not consuming alcohol?
That's not an issue.
Okay, all right. I have no violations, so that's a good thing.
I actually have a more difficult time with the 11 p.m. and 6 a.m. with my work schedule.
Okay. So I show in 17 there was a case handled under 7411. And then in 20, there was an operating while visibly impaired, and 21, an open intox. So that indicates that there's some issue with alcohol. Have you been sober since then?
Yes, actually, I had over a year of sobriety from 24, September of 24 to September of 23 to October of 24. Unfortunately, fell back into bad habits.
What have you been doing to get out of those bad habits?
Maintaining a steady work schedule is a big part of it. I do work seasonally, and because I see a direct connection between the off season and my drinking, in February, I'll be moving down to Fenton to take on a factory position that's year round.
What type of seasonal work do you do?
I work for Mosquito Authority out of Kalkaska.
Okay. Do you think that you can continue to work the services that you need to work without probation hanging over your head, or do you think it's going to be beneficial to have probation out there?
I think the guy, I'm sorry, I don't mean trouble to be disrespectful. I think the guys at my local meeting would really appreciate seeing me there. Without probation to have anything to do with it. I think they'd be very happy to see me.
Have you been attending meetings?
Yes.
All right. Did that start after this case arose or before?
No, I've been going infrequently, less than once a month. It has increased since this event.
Okay.
Work does make a difference.
Well, and there's online meetings as well, if you've got the ability to do those. Anything else you'd like me to know? All right, there will be 1 day jail with 1 day credit. There is a $75 crime victims' rights fee, $50 state minimum fee, $150 fine, $150 court costs. We'll waive the attorney fees. I'm not going to put you on probation. I'm going to trust that this was enough of an eye-opening experience that you've seen what you need to do. You've been on SoberLink since back in June and I don't have any issues, so that tells me a lot. But I want to caution you that, and you know this, that once you're off that sober link, it's entirely up to you as to how you move forward. The choice is only in your hands. I wish you the best of luck with that. And you know what you need to do. You said that you had a period of sobriety. So because I have sentenced you to 1 day jail, even though it's credit for time served, you do have the right to appeal that decision. If you decided that you wanted to appeal it and could not afford an attorney to assist you in that regard, you have 14 days from today's date in which to request the appointment of an attorney. And any balance that remains unpaid for more than 56 days will have a 20% penalty assessed to that. All right. I'll need you to go out to the front window where you checked in, get a copy of your judgment, make payment if you're able to, and then you can go downstairs to community corrections and turn in your device if you have it with you. If not, make sure you do that tomorrow. All right. Thank you. Best of luck to you, sir.
Hey, thanks for watching. Please do like.
iExcel is helping 15 million students succeed in math and language arts.
I will note that for the record, I did receive a sentencing memorandum last week that included a lot of other attachments. I don't think we're not going to go over it, but I issued something last week, which is in the file, just talking about so everybody knew, and I didn't have to deal with arguments about whether or not I could. But this was a no contest plea, and there were several assertions of facts that, to the extent that they disagreed or were inconsistent with the exhibits that the court used for taking a no contest plea, the court does not find it appropriate to consider them. All right, so let's take a look here at the PSI.
The defense did receive the court's order on Friday. Thank you for the court's guidance. We'll go forward. I assume the court did receive all the letters as well.
I did, and I read every single one and made blue ink marks in pretty much every one, so I would remember them.
Court's guidance, Ron.
Thank you. Mr. Denham, now for victim impact statement.
Thank you, Aaron. First, in no particular order, first people would call Miss Gracie running.
I was standing by the fire, surrounded by friends, enjoying the night, when out of nowhere, a gunshot rang out. It took me a moment to process what had just happened. When I looked up, I saw Kevin holding a gun. My mind immediately flooded with questions. Who is this man? Why was he here so late? And why did he have a gun? Around me, I could hear my friends asking the same thing as we were all confused. Kevin and his brother stayed at Logan's house as people tried to figure out what was going on. We all wanted to move on with our night, but the tension was in the air and it felt like it was growing. Then the conversation grew louder. I do not like confrontation, so I decided to move further away, hoping to avoid whatever was unfolding. Then a fight broke out. I heard yelling, followed by another gunshot. That was the moment I realized things were spiraling out of control. Fear took over me, and my first instinct was to get away. I turned and ran towards the woods, trying to distance myself from what was happening. Even as I ran, the fight continued. So hear the shouting, the struggle, and the desperate sounds from someone yelling, "Please stop hurting Seth." But Kevin didn't stop. Thinking, I grabbed my phone and started calling for help. First, I called my dad, voicemail. Then my brother, voicemail. And then my uncle, voicemail. Each call had rang through to the voicemail, and the beating continued throughout each one. Every time the call went unanswered, my panic grew. I was terrified that no one would come in time, and finally I called my mom. When she answered, I blurted out, "Dad needs to come help. Kevin has a gun, he's shooting it, he's beating Seth, and he won't stop. No one can get him off of Seth." Someone else in the woods with me was also calling for help. We just needed anyone at this point to come. But by the time I repeated myself, the fight had finally ended and my friends had came to find me. When I stepped inside the house, I saw Seth. His head was split open, covering his face in blood and clothes. His clothes were covered in blood. He was trying to wipe it away, but nothing could undo what had just happened. We all stood there, shaken, waiting for help to arrive. Since that night, I cannot stop replaying in my head what I saw and heard. The gunshots, the person screaming, and fear of not knowing what would happen next. My most recurring thought, if Seth, a grown man, couldn't defend himself against Kevin, what would have happened to me or anyone else? Kevin's actions that night proved how quickly he can escalate a situation into something violent and dangerous. Someone capable of that kind of aggression, even after people begged him to stop, is not someone I feel safe being around.
Thank you, Mr. Denham.
Thank you. Next, people respectfully call
Mr. Deacon Doty. I wrote down some notes about how this affected my life and all about it. And so at night, I got to sit there and think about my friend's safety, living right next door from him, and how if he can make it through the night, I don't know, just for safety. And then for Seth's safety, after everything that happened, I don't want anything coming back on him and trying to get vengeance on it. And another one, I have to live with the sound of hearing a gun hit my best friend's head about 3-4 times. And I don't know if you ever heard it before. It's not a very pleasant sound. It's going to stick with you forever. And I can't go to my buddy's house, and without worrying what's going to happen at the night, if we're going to make it home safe the next day, all that stuff. And I got.
Can you please just hear me out? No, all work management platforms are the same. Monday.com is the one you'll actually love to use. Did you see the dashboards? They update in real time from your team's day to day, so you're always in control. No freaking way. I don't have to put the data in myself? Are you for real? Monday.com handles all the boring stuff, so you can focus on what really matters. You know what? I'm ready to fall in love again. Thanks, Talking Llama. Monday.com, the first work platform you'll love to use.
In a world where you've constantly been told what you can't do,
who will you choose to be when presented with something different? Be inspiring. Paint your own story of what life could be and what you want out of it.
be authentic, embrace who you truly are and hope to be, as someone who is unapologetically you.
Be thought-provoking. As someone who's been there, share the importance of being your own advocate.
Because schizophrenia shouldn't change who you want to be.
Just no remorse for anything. You know, he's not taking action for it and trying to deny it, even though we all witnessed what happened. It just doesn't set right. All I got for you.
Thank you. And Mr. Denham, I think you said 3.
Yes, Your Honor. Next, the people called Mr. Seth Wilson.
I'd like to start by thanking everyone for being here today. It means a lot for so many people to take this event so serious. As far as what I have to say, I believe the actions of Mr. Scott last November should not go unnoticed or be swept under the rug. The emotional trauma endured by not just myself, but my friends that were there is one thing. You also have to account for the fact that this man is dangerous. I believe that he had an intent for something to go on. There's no other reason for someone to be discharging a firearm drunk, coming onto private property without an invite or even a notice. Personally, in my life, I've seen people go away for a lot less than this. The gruesome and brutal actions that happened that evening will stick with me and my friends for a lifetime. A slap on the wrist is not going to take that away. I do fear for the safety of myself especially, just based on what had happened that evening, without ever even meeting Mr. Scott prior. I had 9 staples in my head the next day when I woke up, along with a gut-wrenching feeling knowing what my friends had gone through and witnessed. It's sickening for someone to approach a group of young adults in such a horrific manner. To be there on the ground getting hit repeatedly and just asking myself if I was even going to make it out. That was the scary part for me, knowing that my friends' lives are in danger from the moment he approached. And for every one of them to not be able to speak in front of this crowd at sentencing was very shocking to hear. They are victims just as much as I am. That is all I have to really say. I know that this should not go unpunished. I believe that there was an intent to hurt or potentially kill that evening. And I hope with all the evidence and statements you can understand where I'm coming from. Thank you, everyone.
Elocution.
Thank you, Your Honor. Just briefly, I'll keep my part short, Your Honor. I've submitted our sentencing memo along with all the letters. The court will note that Mr. Scott has an enormous amount of support in this community. He's a business owner, employs people. What happened that night was out of character and horrible, Your Honor. Mr. Scott is here to take responsibility for his action. I will note his family and friends are here. He does have a lot of support, Your Honor. While on bond, bond was uneventful. There were no violations on bond, Your Honor. And I will note, in his prior, more than 10 years ago when he was younger, he did have some misdemeanor events. But the important thing to note there, I think, is that he was always compliant on probation and bond. I didn't note any violation, which tells me that he takes what this court tells him to do seriously. And he has done that on bond, Your Honor. So with that, I would ask that the court take due consideration of the letters and support. And while this is a no contest plea, Mr. Scott does want to speak and apologize for his actions, but I'll keep it short, Your Honor. Thank you.
All right, thank you. I'll have Mr. Scott at the end after I hear from the people. Mr. Denham?
Thank you, Your Honor. We would respectfully ask that the court order the $2,288 in restitution to compensate the victim, Mr.
Oh, hold on, I forgot to write that down. It's 2,800.
No, Your Honor, $2,288.
Thank you.
So we would respectfully ask that that be included in the order. Your Honor, as we always do, people, we meet with the victims. In this case, we met with Mr. Wilson several times, asking what he would like to have happen in terms of a potential resolution. He indicated in this case that he wanted accountability. He absolutely did, but he indicated in his words that he did not want to ruin the defendant's life. He indicated that he did not want prison. That's what the message that was given to me. Those words, that input was incorporated into the plea offer. I would note that the defendant has pled to 3 separate felonies. We believe that the recommendation, both in terms of the PSI report, as well as Mr. Wilson's recommendation in the PSI report, he's asking for 12 months. The recommendation on the PSI report is a minimum of 10 months. We believe that that's in line with the agreement, and we would respectfully request the court follow the agreement.
All right, thank you. One moment, please. In this case, I don't think a prison recommendation was made. That's no idea how I remember. All right. Mr. Scott, you have the right to make a statement. Now, before I turn it over to you, I understand that Mr. Mankiewicz says you wish to make a statement. I will note that this was a no contest plea, which means whether you do or do not make a statement, they won't impact me. I generally don't think it's appropriate, especially when it's a no contest plea, because there's a reason why the law allows you to enter. Is there anything you wish to say, sir?
Are you researching dental implants?
There's a lot of dental offices that'll talk about doing their teeth.
Honestly, words fail to express how sorry I am for the role I played in that night, and I'll live with this the rest of my life.
I went through and I read every one of the statements submitted, and having obviously been, as I said earlier, in another file, most of my career has been at the defense table. Whenever I read, and I'm not going to ask everybody to chime in, I always wonder if everybody who is writing a letter has read the entirety of the police report that the court has considered, at least in taking of the no contest plea. We live in a small community, both over here in Missaukee County and over in Wexford County. And as we all do, we all tend to know people and overlap knowing people. And I have had people try to send me messages, instant messages and letters, either or even approach and talk to me. A lot of people that I know about this case. I want you to know, especially those who sent me the messages, I don't read them. Once I realize it's going to be about a particular case, I delete it. So I had a couple people, and if any of those people sent me something and they wonder if I read it, the answer is no. Don't send me a instant message on some kind of social media. Don't send me an email. Once I get the inkling that it's going to be about a particular case, it's gone. And then if my friends try to talk to me about it, stop, don't, appreciate it. Thanks a lot. So I just want to cover that. The reason why is because it's ex parte. And here, when I look at these, the sentencing memorandum and the letters, they're all here and open, and Mr. Denhoughton can respond to them. And even so, Mr. Scott can too, through his counsel. I understand there's going to be some defensiveness. There are two different sides to every case, and there's two different sides to this one. This would not, despite the openings of repetitive theory, that's a theme that's in these letters. This was not a compassionate man that day. And there are a couple of people who wrote letters. I can tell you, two of them who were involved in the case, I disregarded your statements. One of them was the person who was a spouse and lied when the police came to doctor her. No, we don't have any of those guns. Even the defendant said, no weapons here, because he hid it outside on a log. Yeah, no. Your letter meant nothing. It didn't help me very much. You lied your tail end off to the police officers. I have no idea what made you think that that was going to be a good approach. When the police officers came to you, you lied. And in this particular case, the defendant lied not once, but lied multiple times when the police officers talked to him about it. There is no weapon. But you just pistol whipped him, was one of the questions from one of the deputies. Nope, no weapon here, he said. Or denied even owning a firearm. Both he and his brother own the same firearm called, which of course is kind of ironic here, the judge. He denied it at least 3 or 4 times. I may have lost count. No. He didn't even get charged with possessing a firearm while under the influence. He's got a significant benefit here. No felony firearm charge with a 2-year mandatory prison term. That was dismissed, which is fine. I'm just talking about the benefit that the defendant gets. By the way, one of the best things here about this case is this defendant cannot possess a firearm for several years, which means any firearm in the house within his custody and or control. That's what the word possession means. Every firearm in that house has got to go. I don't care if it belongs to somebody else. It's within his area of control. And as we talk about in the instructions for the jury instructions, possession doesn't mean ownership. It means area of control. He should not have access to any weapon as long as the law will allow him, which will take a few years before he can ever possess one. In fact, when one of the statements came from the brother, I discounted his statement because in here it says on CFJ 284, page 5, the brother denied that he and the defendant crossed the street.
Why you should never cover your credit card with tin foil. I've worked at a major bank for 14 years. Just yesterday.
Or left the scene at any point after the altercation. Well, the other evidence is they left. So everybody on that side of the street, because these people live across the street, was lying. So the defendant decides that he wants to walk across the street because he's upset. By the way, there's a party going on for kids at his house. And so he doesn't like maybe the noise or whatever's going on across the street out in the country. Something possessed he and the brother, especially while intoxicated, for him to grab a firearm and go across the street, shoot it to scare the heck out of everybody, and then pistol whip. Not once, but he pistol whipped another person. The defendant, while drinking, is a danger to himself and others. He should never drink alcohol again. That is for certain. And I wrote down here, I sometimes come up with little themes, and of course here I focus on the fact that it's a 45 Colt revolver called the Judge. And apparently Mr. Scott thought that day he was the judge. And again, anyone who would try to approach me and talk to me outside, I would ask you, did you read the police report? Because if you did, this police report describes an incident that is woefully different than the person everyone described. What makes a person walk over with a loaded gun while drunk and start shooting it to scare people and then pistol whip another person? Now, I get to use the pistol whip because he did not go to trial, which is fine, which means he waived any self-defense argument or defense of others. One person said they heard the bullet whiz by their head. Another person said that there were actually 2 shots. And then here's another one. While she's not charged, I don't know why she didn't get charged, which is okay. I'm not challenging. Interference. She went across the street, tried to interfere and tell the other people, hey, yeah, this everything's fine, everything's taken care of. Try to downplay the severity of the incident. You can't downplay a severity of an incident. You weren't there, and you're not the one with the lacerated skull with blood flowing down your head. I have no idea what you were thinking. So, everyone, I understand the defense. This is probably, if the defense isn't drinking, he's probably perfectly fine. And by the way, the defendant owns a business. He's got multiple people and family members and employees that rely on him. Great. But none of those employees sat there with a gash in their head with blood flowing over the head with a drunk guy shooting a gun at a piece of property that's not his because he didn't like whatever noise was going on by a bunch of 20-year-olds, who, by the way, probably need to grow up a little bit, but that's just because I'm an old guy. All right. No. Danger to self and others. And I'm really sorry. You got a lot of obligations riding on you, a lot of people counting on you. That is not, the only thing that's going to sway is I'm not going to give you a prison term. I want to send you to prison. And by the way, there's a killable agreement between both sides. Killable agreement means that if I don't go along with it, he can withdraw his plea. You have no idea how tempted I am to give you a prison term. You've got issues here where you've got alcohol that you dealt with in the past. Please note that there are a couple findings, a couple cases here in the past. And I try to make this statement, if they were dismissed, like entry 3 of 7, I of course disregard those. I do note that you completed probation successfully in the past. And I'm going to tell you that's about the one thing you have going in your favor. You do have a 10-year gap. That's the second thing that's going on in your favor. A 10-year gap means that some of those priors don't get scored. The court places the defendant upon a period of probation, the recommended period of probation. By the way, the probation officers who filled this out, you'll note that on here it says their names were withdrawn from it. Lansing doesn't want me to send you to prison because they're probably overcrowded. I do. The probation officer does. He cut a deal with the defense, the prosecutor, and the victim seems to think jail's fine and prison isn't required. So that's what I'm being told. So, all right. The court places the defendant upon a period of probation for 36 months. I adopt the terms and conditions that are listed on CFJ 145, pages 3 and 4. I find that they're well suited for rehabilitative purposes. The court highlights that the defendant is not to possess or use alcoholic beverages or other intoxicants or illegal or controlled substances, and he will be subject to testing. He'll be subject to treatment if directed by the probation officer. Now, while he's on probation, he will have a curfew for which there will be no exceptions, at least according to the court, between 11 p.m. and 6 a.m.
I don't have time for bullshit, so I use a no bullshit pan. I am Chef Sam Talbot. I've been cooking for 37 years.
Of course, with this felony conviction, your ability to possess firearms, will be limited by law, but even while you're on probation, you may not possess any firearms or use any object of a weapon. And I let you know that if there is one firearm in that house, it's gotta go. Don't anyone come to me and say, well, it belongs to Melanie or it belongs to somebody else. It's in his house. It's gone. The defendant will. This is going to be compliant with the Killebrew agreement, although it's going to be different than that which was recommended by the Department of Corrections. Court sentences the defendant to a period of jail for 365 days, and that has 2 days of credit. That will apply to each one of 3 offenses. I note that here, the 2 of the counts are intermediate sanction cells of 2 to 17. I find that pursuant to this law, the guidelines are inadequate to discuss the circumstances here of this particular situation. And yes, I know, folks, I am talking a little bit tough because I want to break through the sugarcoating. I understand that Mr. Scott, probably a good guy, great guy in most situations. But when consuming alcohol and possession of a firearm, you all better watch out. And it's by the grace of the prosecutor and Mr. Wilson, who apparently supports, as I'm being told.
Can I say something about that? Because they told me that there was probably no chance that he was going to get prison time. I didn't tell them I didn't want him to go to prison. That is not what I said.
Okay.
Like I said in my statement, a lot of people, I've seen people go away for a lot less than that.
Okay, I appreciate that, Mr. Wilson. Now I'm
hope it's clear.
All right, thank you, Mr. Wilson. You'll note that why I repeated that statement, that what I've been told, I repeated it at least 3 times. And I looked at you each time because I wanted to see what your head shape was.
Can we strike the attorney fee?
Oh, we strike the attorney fee. Thank you. I'm so sorry, Mr. Nicholas. All right. Well, Mr. Denholm, I thought you said the Mr. Wilson agreed with the recommendation that he didn't want prison.
I stand on my statement. That is what Mr. Wilson indicated to me, Your Honor. We went over guidelines, and those were his statements specifically. So I stand by my statement, sure.
I understand, Mr. Denholm, sometimes in those conversations, understandings between a lawyer and what a non-lawyer hears and says, I got it. So I'm not pointing any negative finger at you. But now I'm wondering, what do I do? All right, well, I have announced the sentence. I'm going to keep the sentence as given. I will note that when there are violations of probation, because it's 365 days, any probation violation could result in a prison sentence, which means for 3 years, he'll have to be perfect. He can't drive, he can't get a driving license suspended, anything else like that. I can tell you though, I wanted to give you prison. This was just a terrible, terrible situation. But I'll tell you, I will not give you work release, which means you're going to stay in there for 365 days minus your good conduct time. You had all of that. And I want to, if any of those people want to come up and say, hey, Judge, my job is more important than a person who got pistol whipped and the gunshots.
Would this make you buy a Ridge wallet? 2 people could win a Lamborghini Huracan Sterrato, a Hennessy Velociraptor.
1/7/20, that's expired.
I'm surprised I'm not getting the same courtesy as the others. Yeah. Okay, I get it.
Mr. Gubin?
I don't need to hear it. I don't need to hear the blabby blab. Just stop talking. I showed the proof, Mr. Sean Perkins.
I'm gonna hold you in contempt, okay? And we're gonna give you some jail time, okay?
Those were scenes from Mr. Gubin's first hearing on February 29th, 2024. I've got the rest of that crazy hearing right after I stopped talking. In the meantime, Gubin the Goober failed to appear a few times, got himself a lawyer, started taking things seriously, and then showed up in person with his lawyer, on time, for court today. His lawyer blamed his behavior in the first hearing on his having the flu. Judge Perkins hears a lot of whoppers, but he promised this Goober jail time for contempt way back when. I'll give Goober credit for one thing, though. When he walked through the front doors this morning for court, he knew he'd be walking out the back on his way to Wayne County Jail. Let's roll, nerds.
Gubin, Joshua Gubin. Joshua Paul Gubin. He was on the iPhone. Maybe he's gone. No, he's not. He's here.
You have to unmute Mr. Gubin.
This is the city of Detroit versus Joshua Paul Gubin. Case number SP1411448. Counts 1, 2, and 3. Appearance for the record, please.
Elwood F. Berry Jr. on behalf of the defendant. State your full name, Mr. Gubin. Joshua Paul Gubin.
All right, good morning,
Your Honor. For purposes of arraignment, we would waive the reading of the information and stand mute.
And we'll enter a not guilty plea on his behalf. We'll give him a $0 bond. No ballot. Hold on a second. No valid registration, never acquired plates, and no insurance misdemeanor. Do you have documentation for this vehicle, Mr. Goodman?
Yes, I do.
Where are they?
Here's the registration.
Hold it up. Let's see what you have. This nice pickup plan on Joshua 1720. That's expired.
But it's still, I registered.
Almost the third month of
Already sold the truck. Like it's sold, but I don't know. The ticket first bought the truck. I got license plate right
again.
after.
I don't understand what you're saying. Say that again.
I had just bought the truck when I got ticketed, and I immediately got the truck registered and fully insured right after, but I sold the truck.
Do you have a vehicle in your name, sir? Now?
Yeah, I do.
Let's see what you have for that vehicle, registration and insurance.
Okay. I have my Progressive app.
You want to send me, you want to send it to my email address, sir?
Sure.
I'm gonna put my email address in the chat.
Okay.
I'm looking for valid registration and insurance, please. Let's pass the matter until Mr. Goodman gets those documentations to us.
I just emailed over the proof that it is my insurance policy, man. Unbelievable, bro.
All right, let's go back on the record. Mr. Goodman, I have a insurance
Top right
policy.
corner. It's my wife and me.
Quiet, Mr. Goop.
I have an insurance policy here. Only thing about this is I don't see a valid date.
Oh God, you cannot be serious. Do you not see the Ram truck right there?
I'm serious. I'm serious.
I'm surprised I'm not getting the same courtesy as the others. This is blowing.
I'm giving you the same courtesy. I'm giving you an opportunity to show me some proper documentation. You showed me some invalid registration first.
Sir, the truck is gone, sir. The truck is it got stolen from me at gunpoint. Insurance paid me off for the truck.
That is not
the policy that you asked for, and you're not satisfied. And I showed you valid proof that the truck was registered.
Please,
Mr. Goodman. Don't say anything, Mr. Berry. Don't say anything, Mr. Berry. Mr. Goodman.
What did he say?
Mr. Goodman.
All I was trying to say was I'm extremely sick. I'm literally throwing up right now.
Listen to me. Listen to me. I'm not. We're not going to talk like this. I'm going to talk, and you're going to listen, and I'm going to give you an opportunity to talk. All right. So first of all, don't accuse me of not giving you the same courtesy as everybody else, because that's absolutely not true. I don't have to dismiss these cases just because you said you had insurance. I can send you straight to trial or make you or not make you take the deal. I can't make you do anything, but I'm trying to give you an opportunity to show me valid documentation, okay?
And I'm trying to.
And I don't see, what I told you is, I don't see a proper date on this insurance policy that you sent me.
All right, I'm going to show you this registration that I had on the Ram, and you will see what day that ticket was issued and what day this registration was issued, which was a month or two after the ticket. So the truck was registered and plated, fully insured after I received the tickets.
So show me the insurance policy, the portion of the policy that has the expiration date. You showed me that registration. 1/7/2024.
So you're asking to see if what? A valid what?
I'm asking to see the date on the insurance policy. You gave me an insurance policy. I have that, but it has no date on it.
All I showed was proof that the truck was insured, registered.
All right, I'm not gonna deal with it. All right, let's set a trial date. Set a trial date.
I'm trying to get this dismissed. This is this is literally holding me back right now.
You get it dismissed on the date of trial. Date of trial.
Nice. Thanks for no, I see clear hey, why I'm not getting the same courtesy. Your name is Sean Perkins? Yeah, okay. I will.
The last time I checked.
Yeah. Okay, I get it.
Mr. Gubin?
Sir, Mr. Gubin, you need to shut the fuck up and stop talking to a damn judge like that. You don't talk to a judge like that. It's disrespectful. It's contempt of court. What a dumbass.
I don't need to hear it. I don't need to hear the blabby blab. Just stop talking to me.
I was just going to ask if you want to go in a breakout room.
What is a breakout room? I showed all my proof. I showed all the proof. I showed the proof, Mr. Sean Perkins. What is it? Is it my, what is it? My complexion?
Have a good
It's my complexion, isn't it, buddy?
Have a good day,
Mr. Uneducated Judge.
Have a good day, Mr. Gubin. You keep on talking out of turn. I'm gonna hold you in contempt, okay? And we're gonna give you some jail time, okay?
Oh shit. No.
You done?
Anything else?
Are you
Anything
done?
else, pal?
All right. I'm gonna hold him in contempt. I'm gonna give him 30 days Wayne County Jail, all right?
Ah, dumbass.
Right, okay.
Told you it was contempt of court.
You have an absolute right to a hearing.
You will accept a huge lawsuit. I showed you every single proof of documentation that I needed to, and you refused to dismiss my stuff.
Have a great day.
Why is that?
Have a great day. We're not talking anymore, all right? We're done talking.
Yeah, that's what I thought.
30 days Wayne County Jail.
Yes, Judge, good morning.
And who are you here on?
I am here on Joshua Gubin.
All right, he has not showed. He needs, I told him to be here in person today, and he has not showed, not neither. Oh, I think he is here. He is here. Okay, so here's the deal. It's nothing really to talk about with Mr. Gubin. I told him to come in. I said I gave him 30-day Wayne County Jail for contempt last year. Yeah, I see him hold up a child. His child, he didn't come down. So again, he continues to defy orders of the court, and we just don't have much to talk about.
Well, Judge, I understand that may be the court's position as it relates to this matter. May I have just 1 second?
We've been using IXL for as long as my kids have been in school as just a supplement.
I apologize,
Exactly,
Judge. I needed
what a dumb
to
shit.
plug my computer in. So I understand that may be the court's position. I just got retained on this matter this morning. I was not present at the hearing where you apparently held him in contempt. He obviously has an opportunity to prepare and present a defense to the allegation. I'm not sure if the court made a finding as to whether or not this was civil or criminal contempt, and further, whether the court actually determined whether it was direct or indirect contempt. Obviously, the court's ability to sanction an individual, especially with a deferred sanction, may be limited under these circumstances. So what I'd be asking the court to consider doing is giving me a brief adjournment so that I may obtain a copy of the transcript of the last hearing. And I would just cite to case law, which indicates that my client does have the ability to obtain an accurate transcript of the hearing as a matter of due process. And when we come back, I will be prepared to effectively, properly address this matter.
Well, the contempt was, the contempt was right on the record, on the record, and I do have, you can get the record for that. It was, I did hold him in criminal contempt. That's why I told him 30 days Wayne County Jail. And from my understanding of the court rules, he had his opportunity to contest that. That ship has long sailed, from my understanding of the court rules, because this was done over a year ago. And the only reason that Mr. Gubin has come back before me is because he got some other cases. He let the tickets go on the warrant status. He only is before me because he got the other cases. So I still need his presence here. I'm going to readjust his bond now.
Well, Your Honor.
So he continued, I'll let you speak, Counselor, and I'll let you do what you need to do as far as your job, but I'm going to do my job. And Mr. Gubin continues to defy the court's orders, and we'll talk about bond right now. City of Detroit versus Joshua Gubin. Case number is SP 14114481, count 1 and count 2. SP 1669671. Appearing for the record, please.
Yes, good morning, Camilla Barkovic, appearing on behalf of the defendant who is present.
Your Honor, Rami Hijazi, P82830 on behalf of defendant as well, Your Honor.
Okay, so you can make the record now as far as what you want to do, either counsels if you want to, as far as Mr. Gubin is concerned. Today, we'll call the date and time. There's 2 warrants out for Mr. Gubin's arrest. Let me see what the action was the last time. Mr. Hijazi was here last week when he appeared on Mr. Gubin's behalf after Mr. Gubin showed up, and I realized that he was the gentleman that was just very, very contemptuous on that day that he was here last year. The allegations were made on December the 7th, 2022. Mr. Gubin was arraigned on those matters on February 29th, 2024. There was a show cause scheduled for August the 15th, 2023. And the register of action can reflect all the other necessary court dates that were had. But Mr. Gubin has showed that he does not comply with the court's orders as far as appearing before the court. Mr. Gubin has shown that he is very, very contemptuous. This is not something that I have done except for one other time. And Mr. Gubin, I gave him a week from last week to get his affairs in order to turn himself in, and he's still not here. Go ahead and make speak to bond.
Thank you, Judge. I've already articulated some of this to the court off the record, but I was just retained to represent Mr. Gubin in this matter this morning. I am asking for an adjournment of today's hearing so that I may obtain a copy of the transcript of the hearing that was held where you apparently held Mr. Gubin in contempt. He does have a right to counsel in any contempt situation. In addition, he does have a due process right to obtain an accurate transcript of the hearing. I would like to obviously obtain all relevant information and then address this matter appropriately. I'm asking that you take no action today and give me the opportunity that I am requesting on behalf of my client. And if you'd like me to transition into the bond issue, I am happy to do that as well.
I'll let you go ahead with bonds.
Thank you. Your Honor, it is my understanding that mere traffic matters are pending before the court, at least one civil infraction, and I believe a no insurance misdemeanor. These incidents date back to 2022 based on my review of the Register of Actions. He has appeared in connection with this matter, which the court has noted. Apparently, he was here last week, and you may have recognized him. But the point of the matter is, I've known Mr. Gubin for a while. He always appears as required and as instructed. I understand that the court may have a difference of opinion as it relates to that, but I would attest to that. He is a lifelong Michigan resident. He has extremely strong family support. He is a father. He has minor children, actually one of which is visible on the Zoom as we currently sit here. He owns his own business in Wayne County and operates that business very successfully. I think when you consider factors that are relevant to a bond inquiry and are not relevant to collateral matters such as prior actions engaged in allegedly before the court, personal bond is warranted, and it's my understanding that that is what may have been previously entered in connection with this case. Upon conviction of the only misdemeanor with which he presently stands charged, his maximum sentencing exposure is minimal. He is obviously presumed innocent at this point in time. And for all of those reasons, Judge, in addition to other reasons, such as his lack of any significant or substantial criminal history, which is a factor that the court shall consider when it sets bond, I believe a personal is warranted. And retaliation for what allegedly occurred in the past should not impact bond under any circumstance.
If you were ever inappropriately touched by a rideshare driver, don't ignore this. You could be entitled up to $580,000 or more in compensation, but there are strict legal deadlines approaching, and once they pass, you may lose your chance to take action forever. The process to follow is simple. No public exposure, no police records required, no physical proof necessary.
All right, well, bond is gonna be set at $2,500 cash. I still, the order of Mr. Gubin still showing up because despite what you've articulated on the record, Ms. Rockridge, I we put the warrant out for Mr. Gubin's arrest a long time ago. He was supposed to be in person here today. He's not. He also has an assault and battery case that he has a warrant out for his arrest for as well. So he showed the court and demonstrated to the court that he has not only with this court, but with the other courts and other judges in this courthouse that he has a failure to appear or something. So bond is $500 cash, and it's still ordered that Mr. Gubin show up in person to the court for the conviction hearing, and we will address and you can appeal the matter to a higher authority if that's what your client chooses to do.
So, Your Honor, I have a comment as it relates to a cash bond. I'm asking that the court impose a cash or surety bond. My interpretation of the court rules as it relates to bond and statutory authority allow the defendant to elect whether he posts a surety or posts a cash bond. And my position is the court cannot outright prohibit a surety. So I'd ask for the addition of a surety provision.
The court has made this ruling, Counselor. You can take it to a higher authority.
Thank you.
Thank you. All right, who's next? City of Detroit versus Joshua.
Yes, good morning, Camilla Barkovic, P78254, appearing on behalf of Mr. Joshua Gubin, who is present.
Good morning, Mr. Gubin. State your name for the record, please. Good morning, Joshua Gubin. Today is the date and time set for a pretrial. I do have an offer here, which is pleading responsible to. Hold on, Mr. Grant. Is pleading responsible to the count of limited access 1 to 5 for the speeding, and as charged, I'm thinking of the improper equipment.
That is correct, Judge.
And then other matters are to be dismissed. Is that correct?
That's accurate.
You want to take the deal, Mr. Gubin?
Yes, Your Honor.
Will you stipulate on behalf of your client to the basis of the ticket as an accurate factual basis for that responsible plea on your client's behalf?
Yes, Judge, I
Will you
will.
stipulate the probable cause for the dismissal of the other matters?
Yes, Your Honor.
All right, I'm going to find your client responsible for the amended count of limited access 1 to 5 for the speeding based on that stipulation, and as charged to the improper equipment.
Thank you.
It'll be $125 for the limited access 1 to 5, and $120 for the speeding ticket. I'll waive the warrant fees,
Thank you, Judge.
and he'll pay any reinstatement fees, which I don't see. Anything further? We're gonna take him into custody.
Well, Judge, I wanted to ask that you respectfully reconsider your position. I reviewed the record of the hearing in question. I understand that my client's conduct may have been considered disruptive and disrespectful by the court. A lot of time has passed since that occurred. That's no justification. But I think it's important for you to know the circumstances under which his actions occurred. So unfortunately, my client was suffering from the flu extremely bad that day. He remained on Zoom for an extended period of time. I'll even attest, I have sat on Zoom for an extended period of time, and oftentimes it becomes extremely frustrating. Obviously, this court moves its docket. This court is very accommodating. But given his illness and given the circumstances, he was not a happy camper. Again, that is no excuse for his actions towards the court. You obviously don't know Mr. Gubin. You probably never will. I've known him for an extended period of time. He is not who this court may think he is. He has always been respectful, diligent in addressing all of his obligations. He's 27 years old. He does not have any significant or substantial criminal history. He's married. He has 2 minor children who are absolutely beautiful. His pride and joy. He owns and operates his own business in Wayne County, specifically a gas station. His wife doesn't work. He's the sole provider for his family. Judge, if you would consider not imposing a jail sentence at this time, and maybe imposing an alternate sanction, which the court has authority to do, such as a fine or anything else that this court deems appropriate, such as community service, my client will gladly accept that. I do know that he wishes to make his statement directly to this court, and I'll allow him to do that at the present time if the court would permit.
Well, let me say this. I appreciate your argument and your diligence on the behalf of your client. I went over and I reviewed
Yes, I'm on row. They say GLP-1.
And I thought I exercised the utmost restraint in the blatant disrespect that Mr. Gubin. And let's go back to your about the Zoom. And there's always an opportunity for an individual to come in person and sit in the court.
Sure.
So that's sort of like, the court looks at that as sort of like a benefit. You know, we allow people at work, we allow people at home who are sick. I didn't know he was sick until he mentioned something about being sick in the middle of, toward the end of what, but that's of no consequence of the court. I really don't care about him being sick. His obligation, he could have said, I'm sick and can we pass this on? But it was every attempt to the court tries to offer individuals an opportunity to show documentation, which court doesn't have to do that.
I know.
If he didn't have proper documentation at the time to stop, the court doesn't have to take that extent in dismissing the case because it's bringing proper documentation now. It is the court's view of Mr. Gubin's actions is that Mr. Gubin was trying to deceive and perpetrate fraud. Mr. Gubin was given multiple times showing proper documentation. And we take it and we'll look at it on the screen. So he doesn't have to email it. He doesn't have to send it. He sends the first document. It wasn't valid. I said, Mr. Gubin, he indicated to the court that at first he indicated he got the truck, but he sold the truck. That was his first argument about what happened to the document. I said, do you have a truck? Do you have a valid document in your name now? He says, yes, I do. Then he emails the court the document, which I'll find in the record and I'll put it in the file. He emails the court a document that shows me this deck sheet of insurance, but that insurance never had a date on it. So I addressed that with Mr. Gubin, and this is all in the record. And I asked him, hey, this doesn't have a date. Then he proceeds to show me another document that doesn't have his name on it, anything. And when we brought that up, and then that's when things went further downhill. So I don't think Mr. Gubin's actions had anything to do with him being sick that day. I don't know whether he was sick or not. And again, I don't care at this point whether he was sick or not. I tried to exercise every bit of restraint. Then he further argues with the court and tells me, while he's swearing, that the truck was stolen at gunpoint. That was his other argument. First he says he sold it, then he says it's stolen at gunpoint. Then Ms. Harris tried to step in and try to mediate the thing and calm the situation down. Mr. Gubin was not trying to hear that. And then Mr. Gubin goes all the way and puts race into the argument that it's because his complexion that I am the way I am, and I'm doing him the way he felt I was doing him, which was absolutely not the case. And I still was exercising restraint and not doing anything. He calls me uneducated. He starts to throw names and things like that. So that's why we're here. We're there. Then there's going to be a huge lawsuit, So that's why we're here. Furthermore, this happened in February of 2024, February 29th of 2024. Mr. Gubin had ample opportunity to come to the court and try and rectify or bring it in. Mr. Gubin knew the court imposed a contempt sanction on him before he left the court, and he never did. The only reason he's back in here now is because he got more tickets. I told him to show up in person multiple times before he hired you, Ms. Barkovich, and he disobeyed the court's order. So at this point, the only sanction that I think is going to get to Mr. Gubin is a term of jail.
Your Honor, may I respond to some of your commentary? I'm not here to quibble with you, but that was something I needed to discuss with Mr. Gubin once I actually became privy to the transcript, the inconsistencies with his representations to the court. I will tell you that I have received information that both statements he made to the court with respect to the vehicle were in fact allegedly true, in the sense that his vehicle was stolen. He apparently has a police report depicting that it in fact was stolen under the circumstances he represented. The vehicle was allegedly then recovered, returned to him, and then he subsequently sold it. So I can understand why the court thinks he attempted to perpetrate a fraud because he advanced seemingly inconsistent statements, but it is my understanding that he has application to back both of those points up. I'm not sure if that makes a difference to this court, but if it does, I'd ask for an opportunity to present that to the court. I understand my client made some statements which should not have been made, and he'll acknowledge that. I didn't advance his illness as an excuse, but I mean, we all know as human beings, any time we are not feeling well, we become more jumpy or, you know, less tolerable. So he apologizes sincerely. He has remedied all issues as it relates to his license. He actually has a valid driver's license at the present time. His car's insured, it's registered. I understand that you think a jail sentence is an appropriate sanction. If you are insistent on continuing to maintain that position, which you can do because you're the boss here, Judge, I'd ask that you consider a reduced sanction and give him a week.
What you want to do is save hundreds when Liberty Mutual customizes your car insurance.
That's great, but can you?
I've heard the argument, y'all let your client speak. If he chooses to, you don't have to if you don't want to.
You would like to, Judge?
I just want to start off with an apology. I apologize for my actions. They were totally uncalled for that day. And I made some terrible misjudgments, and I'm completely wrong for that on my part. And I don't want to try to defend anything I said that day because there's nothing to defend. I was completely wrong.
I can't. I just should have done that last time.
You gotta mute yourself. What?
I just believe that things were just misunderstood that day, and the documents that I was showing, it was misunderstood, and I lost my cool because I was very sick that day, and it's just a terrible mistake I made, and I regret it deeply. So.
Is that it, sir? This one document, Ms. Barkovich, that there was a deck sheet or part of a deck sheet that he sent me. It had pages 3 or 4. This is the reason why I say intended to perpetrate a fraud. He could have sent this whole document. We all have insurance policies, and we know what those documents look like. And I have page 3 or 4 here. And I think he intentionally sent me these pages because he knew that if he sent me the pages that we were actually looking for, it would have had the proper data. Secondly, I wasn't misunderstood about anything, sir. I don't know why you were so misunderstood. I thought it was very clear in an effort of what we were trying to do for you. Whether you say it's sickness or anything, I take the uneducated comment as a racial troll. You know what I'm saying? I don't, you know, we've heard that in the tennis match the other day. The one of the players lost, and she calls the player uneducated. We hear this uneducated toward Black people, it seems like more and more. So that's how I take that as well. So I don't think that I wasn't misunderstood about anything. You turned a simple misdemeanor, no insurance, no registration, or whatever it was, into all of this. And this is the consequence you're going to have to pay. All right? I believe he was contemptuous. I believe he disrespected the court. I believe he basically was making a mockery of the whole situation. So I don't feel any, I feel you intended to do that, and I don't feel it became because you were sick. Okay? So that's it. I can give you the information that he gave the court on that day as a way, but everything he passed off to the court was either not valid at the time, or we would have given him time to get insurance. We do it constant.
I understand.
All right. All right. So I'll consider the reduction, but I'm not. He's going to go to jail today.
I understand, Judge.
So you can, Ms. Markovich, I'll pass the matter. You can go ahead about your day. You can zoom back in. I've heard your argument and I'll make a decision before the day's out on if I'll reduce it.
Thank you, Judge.
Mrs. Markovich,
I'm sorry, Judge, did you say my name?
and I'm gonna go ahead and reduce it to 2 days for your client.
Thank you so much, Judge.
So like I said, it'll probably be out tomorrow, I don't know. But it wasn't, I appreciate your argument on behalf of him, but I don't believe it.
On the record?
No, this is, if you, I can record, and get the file of Mark, that, then, we'll 2 days gets it entered.
Thank you, Judge. He sincerely appreciates that.
I'm sure he does.
I do too. And thank you for your time today.
But I really wasn't doing it for him either.
I understand. Thank you.
All right. All right.
Wow. Pretty powerful stuff today. I want to say this so that people understand, okay? I technically retired from doing computer repair stuff because one of my neighbors went down to the office and told a bunch of crap to the community manager or whatever you want to call herself, and somebody from the company. So they told me I can't do it anymore. I hate it. I really hate it. It took me a while to find out what I wanted to really do on this channel, and it was, I don't remember whose suggestion it was to do courts and court cases. And I think people are actually enjoying this content. The channel has jumped quite a bit in numbers since then. I think we had, 50, 70 people one time. Now we're up to almost 80. So, yeah, that woman went down there and told them lies about me, and that I was repairing computers without a license and everything. And that's why I took down my first YouTube channel. Then I created another channel, and we all know what happened with that channel. So it took me a few minutes to figure out what I wanted to do. I want to thank Trin. She's been with me for over a year and a half now. She's a good moderator. She takes care of business. And there's no drama. Ever since I created this channel, there hasn't been any drama. There's been no crap on here. It's been peaceful. And people are telling me in the comments, I saw the other day, I don't know if it was Gail Judkins, or it was, I think it was Gail, said that it was Gail. She said that she liked these chill streams and were able to listen to these court cases. And I don't mind bringing that stuff to you. And thank you, Trin, for being by my side. But everybody else abandoned me. The other thing it pisses me off is YouTube is fucking with my numbers now. Yeah, it does, John. It does. And I had to take down an entire YouTube channel that had back then it had 250 subscribers. The first channel I had 250 subscribers. And I had like 300 videos and a lot of computer stuff. a lot of computer repair stuff. And I was stupid not to make copies of that stuff. I'd rather talk about courts and court cases. I'm interested in this stuff more than I am fixing computers. So, to all the new subscribers to this channel, thank you, and welcome. Welcome to my channel. Welcome to my platform. To anybody that's not a subscriber to this channel, if you like the content that's being put out on this channel, please consider subscribing to this channel and hitting all notifications. You're helping this channel grow on its own, and that's what I wanted. I wanted this channel to grow on its own without being promoted, without, and it's working. It's slow, but it's the numbers are, everything's looking good. I do appreciate everybody. I really do. If YouTube would quit screwing with my damn numbers, so tomorrow is landlord-tenant. Tomorrow is our landlord-tenant docket, and then Monday would be Judge Flesher, which I love Judge Flesher. I don't give a rat's ass if I like him. I don't give a rat's ass if Mother Teresa has to go to church. Do not drive. He is out there. So is Judge Simpson. And just remember, these channels that post that content stuff can't say it's the original content. If it's a court case that was zoomed, it's not the original content, so they can't strike me for replaying it. Because under the Fair Use Act, allows me to play that back again. Yeah, I know. And this whole thing is, I want to briefly say that this whole thing that's going on right now is a shit show, and that's why I don't talk about it on here anymore. It's out of I don't talk about what's happening with respect to Michelle and John and HG. So I wish you and Michelle luck. If you need to talk, you can come on and talk in the chat. I'll be glad to interact with you. But don't, half the stuff that I listen to, I just don't. I stopped listening to it after about an hour. So I might listen to an hour of somebody and then stop listening to them. So yeah, that's about it for today. Tomorrow's our landlord-tenant docket. Yeah, and eventually people are going to get tired of it, Trin. Eventually people are going to get tired of all of it. I think on both sides, people are starting to get tired of it. And again, I will say this, there's no ill will for Ray Bonecrusher. I'm sorry that your wife passed away. I understand that you're going through a grieving process. I lost my mom. I miss her so much. But that's it for today. Tomorrow is our landlord-tenant docket. I'm going to try to mix that up a little bit. Do a little Judge Simpson, do a little Judge Middleton. So that's it for today. Ciao, ciao, ta-ta. You all have a good evening, and I will see you again tomorrow. So, yeah, tomorrow is our landlord-tenant. You all have a great evening, and I'll see you again tomorrow. Ta-ta, ciao, ciao, and I will see you again soon. Have a good day.
Never give up on this heart of mine. Put it back together every single time. Fix it all, fixing your hour, standing tall, tall. To all you do, from the highest peak, I can see it through. With your care and touch, everything's okay.